Some of you in the audience will know that aspects of what I'm saying applies only to some rather than to all countries in the region, and I simply ask those people to accept my apologies at this point. The generality of my language is not born of ignorance of those differences, but rather of my need to provide a regional proposal in a fairly short period of time. So here's an overview of what you're about to hear in the presentation. First of all, and I guess for the majority of the presentation, I'll be talking about legal mainstreaming of climate change, in particular climate change adaptation in Pacific Island countries. Then I'll raise some examples of some recent legal reform, particularly in Samoa, Vanuatu and in Kashrai in the Federated States of Micronesia. Then I'll just identify some of the key threats to effective legal reform and effective responses to climate change in the region. Then I'll summarise with some recommendations towards the end of the presentation. So this diagram here provides a simplified illustration of the processes involved in mainstreaming climate change adaptation, with an exclusive focus in its lower sections on legal strategies and their consequent outcomes. Climate change mainstreaming, as most of you know, is the process of integrating concerns regarding climate change adaptation into all aspects of governance. Climate change may be a problem born of environmental change, but its impacts affect all aspects of governance, indeed all aspects of life. So the orange components indicate the various sectors that either have or will undergo policy reviews with a view to integrating into them concerns regarding climate change. There are others. I know the FSM National Policy on Climate Change identifies gender as a separate sector to be considered. Water and energy should probably also appear in the orange section of the diagram. The blue components indicate regulatory strategies that can be adopted if, following the review process, some regulatory response is regarded as necessary. The yellow components indicate the various intended outcomes. These may be climate-proofing new development, the importance of which was emphasised so much in the previous session, creation of incentives for appropriate adaptive behaviour, disincentives for maladaptive behaviour, and direct regulation to restrict or prohibit maladaptive behaviour. So some of the sectoral reviews, once undertaken, are more likely than others to give rise to direct regulatory responses or to market-based responses that require legal bases. The sectors most likely to require legal responses, at least in the countries with which I'm most familiar, Vanuatu, Samoa, Solomon Islands, Federated States of Micronesia, appear in this diagram in the darker orange colour. Now, a necessary prelude to the material and analysis that follows is a brief introduction to legal pluralism. Legal pluralism is a fact of life in most Pacific Island countries. Most of you would be familiar, I would expect, with the concept of legal pluralism, but for those of you who are not, I'll simply describe it as more than one legal order observable in a given society. In most Pacific Island countries, vibrant systems of customary law operate alongside the ubiquitous state, the ubiquitous state being ubiquitous in its claims rather than necessarily in its influence. In fact, in the day-to-day lives of most rural Pacific Islanders, customary law is a more significant influence in directing behaviour, maintaining order, allocating land and resolving disputes than state-based legal systems. The accuracy of that statement will be highly variable in different countries, different islands, and for different issues. In Kashrai State, in the FSM, where I lived for a number of years, due to various historical factors, there is virtually nothing that could be accurately termed customary law. Conversely, in Yap State, in the west of FSM, customary law is so powerfully integrated into the polity that traditional leaders have a power of veto over any law of the Yap State legislature considered by them to be inconsistent with Yapese custom. In rural Vanuatu, I emphasise in rural Vanuatu, these things are differently experienced depending on the urban and the rural sectors of the countries. rural Vanuatu, rural Solomon Islands or Fiji, customary law is equally influential in people's lives as it is in Yap, often more so than state law. So where customary law is a significant influence, it almost always has claims over issues that relate directly to climate change adaptation, such as land use, such as management of natural resources. So the reason that I was keen to mention legal plurality in the Pacific today is because it is central to understanding the most appropriate and effective legal responses of Pacific Island countries to climate change for a number of reasons. Firstly, consider the capacity of government. Pacific Island government capacities, human capacities, technical capacities, financial capacities are very often severely limited. This makes coercively regulating the behaviour of their citizens, particularly in remote locations, virtually impossible. I've worked both within and also on behalf of Pacific Island government departments, and I know how few staff and resources are available to many of them, as well as the challenges they consequently face. For example, in Vanuatu until last year, a country with 82 inhabited islands stretching over 1,300 kilometres from north to south, there were only three staff in the Vanuatu Environment Unit, two of whom spent most of their time at international meetings in New York or Washington or Geneva, and the other one of whom was an administrative assistant. Happily, that number has now tripled, so the capacity is increased. It's still severely limited. So that lack of state regulatory capacity exists in many areas of governments, but is especially acute with regard to issues over which custom also stakes a claim, most notably for present purposes, land and natural resources. Also, because of the high value placed by local populations upon customary tenure and local control of land and resources, coercive state regulation of natural resource use is frequently perceived as illegitimate and is resisted for that reason. What this means is that direct regulation of maladaptive behaviour of citizens by the state will frequently be an inherently weak strategy. It simply won't work. By maladaptive behaviour, you would have gathered from the previous session indicating things depending on the site, depending on the island, depending on the ecology, things like mining sand from beaches, clearing the mangroves and other coastal vegetation, fishing using damaging methods. So, what is the alternative to direct command and control regulation? Well, of course, if command and control regulation won't work, then perhaps the power of the free market will. However, given the nature of Pacific Island economies and societies, there are limited applications for market-based mechanisms to be applied for climate change mitigation, and even fewer opportunities for adaptation. This, again, is for a number of reasons. Pacific economies, generally on a national scale, are fairly small. Foreign markets for exported products are remote and relatively difficult to access. Local markets are small with limited competition amongst market players. And finally, and fundamentally importantly, many Pacific Islanders subsist partially or entirely outside of the cash economy. But in suggesting that market mechanisms have limited applications for climate change governance responses in most specific contexts is not to suggest they don't have a place, so there are no applications. One example would be the taxes placed upon foreign food imports as a means of maintaining food security by encouraging local food production. This is done very actively in Vanuatu, and although the taxes were not originally devised as a response to climate change, they were very consciously an intentional strategy to maintain local food production. And maintaining food security in the face of a rapidly changing climate is a very good reason for Vanuatu to continue to resist the fairly active World Trade Organization pressure to remove precisely those taxes. So, in summary, market mechanisms are included among the regulatory tools for successful climate adaptation in Pacific Island countries, but they probably shouldn't be regarded as a central component of it. So if direct state control is unlikely to be effective in most situations, and if the market is equally limited in its influence, then what is the most appropriate strategy to employ when seeking to restrict or prohibit maladaptive behaviour? A great deal of experience in sectors such as inshore fisheries, protected areas in the past 30 years indicates that community-based approaches are most likely to be successful in Pacific Island contexts. That's something I think that resonates with Albin's presentation in the last session. In the past 20 years, there have been more than 300 protected areas established in Pacific Island countries, and every single one of them has either been initiated entirely by local communities or more usually undertaken in cooperation with them by civil society organisations or government. These protected areas often draw upon traditional ecological knowledge, but they are always founded in people's deeply felt belief that natural resource governance is most appropriately undertaken at the national level, at the local level. These approaches are now being applied to climate change adaptation. So, community-based programs of this kind are undertaken differently in every jurisdiction, yet there are two principles which are common to each. The first is the notion that local level institutions should be the primary decision makers, and the second is that they're typically built upon partnerships between local level institutions and external agencies that are able to bring to the table knowledge and capacities that are unavailable to communities acting in isolation. Increasingly, we are also seeing two additional elements emerging in these programs, particularly during the past decade. The first of these is that there are networks developing between local level institutions. The Fiji locally managed marine area network that you can see images of on the screen has over 200 local sites spread around Fiji, all connected in a single national network. The second emerging feature is that the local level institutions are now looking more and more to government to provide a legislative basis for what they are doing, in effect to unite the authority of custom and the state to close any gaps or weaknesses in authority by underpinning local non-state authority with state authority. The image on the screen is an excerpt of the table of provisions of the Samoan Fisheries Bill that is in its final stages of completion. The Samoan Fisheries Department has been working cooperatively with Village Whānau in Samoa since 1995 in helping them to develop village-level rules for coastal fisheries. This has worked very well, and now there is sufficient trust amongst all the parties to fully express this mechanism in law. Moreover, Samoa is now building upon this experience of the past 16 years by working cooperatively with Village Whānau to develop local-level climate change adaptation plans and, where necessary, to support those plans with village-level bylaws. This kind of mechanism is occurring in many countries throughout the region, in Vanuatu, but it's occurring in different ways depending on the jurisdiction. In Vanuatu, government agencies and civil society organisations are working with networks of what are being called community disaster committees. These are village-level committees that have been set up for disaster response planning, but are also now being engaged to undertake climate change adaptation planning. The committees in turn communicate with their local customary leaders. They're being supported by NGOs such as the Red Cross. This again is proving very successful. In Fiji, working along similar issues with the Fiji locally managed marine area network, and there are many other examples that I could show you from around the place. Now, these are just two images of local level action for climate change adaptation. There was a bit of discussion on mangroves. There's an image from Kashrai on the left there with some community members replanting mangrove clearing, making sure that's been over-harvested, making sure that regenerates properly. And the smiling gentleman on the right has just won a competition for collecting crown-of-thorns starfish on the island of Pele Island. In a single day, the villagers of Pele managed to collect more than 5,000 of these animals, which were invasive species on their reef. Again, the marine biologists are telling us that was an impact of climate change. The crown of thorn starfish eat the reef, destroy the reef. After the collection, the animals are composted, used to make soil. Soil is used to propagate coastal vegetation species, which are then used to plant along the coast, further increasing Pellé's climate resilience. Here's an illustration provided to me by Professor John Hay, adjunct of the University of the South Pacific, been working in climate change adaptation in the Pacific for the past 25 years or so, with both governments and with communities. And it's essentially just illustrating the learning process which has gone on in this area of governance. We have a continuum on the left from decentralised bottom-up processes to centralised or top-down processes. You can see the proliferation of activities which is occurring in recent times, beginning in the 1980s, and then the clear trend is for most activity in recent times to be very much at the decentralised community-based level. And the reason for that is because 25 years of experience has indicated that that's what works best. So finally, in terms of legal strategies for climate mainstreaming, improving and applying effective environmental planning, including land use planning, environmental impact assessment that takes account of likely impacts of climate change is essential in all jurisdictions, including in Pacific Island countries. This is among the central regulatory function for government legal responses in adapting to climate change, and we will see from the illustrations that I'm about to present, it is where Pacific governments have commenced climate-specific legal reform. So the first of these, which I'll go through quite quickly because the Secretary for Justice from FSM is going to speak later in the session. He might well want to speak about this. This is a law passed by Kashrai State very recently to meet its own climate adaptation needs in a regulatory sense. It's not particularly complex. It's a matter of keeping it simple, but it's nevertheless an appropriate first step towards adjusting Kashrai's legal frameworks for climate change. It was signed into law by the Kashrai State Governor on the 11th of March this year. Three key elements: new public infrastructure, drawing on the presentations we heard in the previous session. It's so important. New public infrastructure funded by donors or locally funded now must be located and designed taking account of predicted climate changes and impacts. Environmental impact assessment. The environmental impact assessment process in Kashrai now must include consideration of climate impacts and adaptation options, and Kashrai's building code now must be rewritten in order to include climate risk reduction and adaptation measures. There's an illustration, Tafansak village. That's the key piece of infrastructure in Kashrai, the Round Island Road. It's the only way for two of the villages to get to the main centre, and as you can see there, it won't take too many more of those extreme weather events before it's been reclaimed by the Pacific Ocean. It's a very acute problem for Kashrai at the moment that they're working on. So moving on to Vanuatu and what Vanuatu is doing in terms of legal responses to climate change. It's also already undertaken a limited amount of reform, and there's a great deal more in the pipeline. The central piece of environmental regulation in Vanuatu is the Environmental Management and Conservation Act. That was amended, amendments drafted last year and passed into law this year. There are quite a lot of them in the Act, but I'll just focus on the three central ones. The first of which, probably the most important of which, is a very strong statement. Precautionary principles been included and defined and must be applied in all decisions made under the Environmental Management and Conservation Act, not only by the people who are administering the Act, but also by all of the people who are being regulated by the Act. The definition of significant environmental impact now includes considerations of climate change. That's a defined term which in turn triggers various other obligations under the Act, including those relating to environmental impact assessment and also various offence provisions. And again, similar to Kashrai, climate-related considerations must be included in environmental impact assessment. So that's what's already happened in Vanuatu, and this is what is being planned to happen. There's going to be a complete review of all foreshore development and land use planning legislation. As was noted by, I think, Alban in the last session, that's going to be a very politically fraught process, but nevertheless it's going to be undertaken. with the result that we're going to have completely revised land use planning, town planning laws. There's also been the forest review, so the forest sector review has been completed, and one of the outcomes of that was a recommendation that all forest-related legislation in Vanuatu needs to be consolidated and updated, taking account of various things, including climate change impacts. And finally, there's going to be the development of the legal infrastructure to enable Vanuatu to participate in carbon sequestration markets and RED programs. Now, considering what was discussed yesterday with regard to the land use planning laws, they may include consideration of issues relating to internal climate-related displacement, which is already beginning to occur in Vanuatu. Vanuatu does have one atoll community. It also has many dozens of coastal communities, some of which are experiencing severe impacts from sea level rise and coastal erosion. But this land use planning legislation won't necessarily deal with those issues. Even within a single country such as Vanuatu, the complexities and uniqueness of each displaced or potentially displaced community is such that it is most likely that the government will seek to respond to these events in ways that are geared specifically to each event. I can't delve into the reasons for that right now because of issues of brevity, but I'd be happy to answer any questions on it if some of you are interested. So, progressing to the threats to effective legal responses to climate change in the Pacific, divided them into internal threats and external threats. The internal ones fairly self-apparent from what I've just been saying. Lack of intersectoral policy coordination at the national level is a fairly significant threat. Best illustration of that I can give is we have, on the one hand, a team within the health department who are focused on malaria eradication, busily going around some of the islands and suggesting to people that they need to clear the mangroves in order to stop mosquitoes from breeding. And then, of course, we have the people concerned about climate, about the sea level rise and the coastal erosion within the Environment Department who are saying, well, the worst thing you can possibly do is start clearing mangroves. So that sort of thing needs to be resolved at a national planning level, and that sort of lack of coordination is obviously very wasteful, inefficient, confusing for people. Building and maintaining cooperative relationships between state and customary institutions with regard to climate change adaptation obviously flows from what I was saying about the effective mechanisms for direct community level regulation. Now, the external threats both related to donor funding, and the first of these is a lack of coordination among donor-funded projects, and the second is donor-driven preferences inhibiting effective development of appropriate laws and policies. And perhaps this image will give you a feel for what I mean. There have been many complaints that donors aren't doing enough for climate change adaptation in Pacific Island countries. Whilst I won't disagree with that, I do know for a fact that there are many millions of dollars of donor money that is unspent in certain Pacific Island countries because it is mainly because it is poorly packaged and delivered, partly also because of a lack of local capacity. And there is much more that could be achieved even with existing levels of funding. There are significant opportunities to improve the manner in which donor assistance is being delivered. In brief, there are too many disparate programs which are poorly coordinated at the international level and are simply more responsive to donor priorities, donor preferences and donor processes than they are to local or national plans and processes. As you can see, there are 20 donor-delivered climate-related inputs coming into Vanuatu alone. All those programs and projects at this stage are managed by one person within the Vanuatu government, including all of the planning and reporting. Hopefully that one person will soon be expanded to a team of people, but even so, it is a thoroughly project-based and disaggregated program. So, what's the solution? I'm not a big fan of buzzwords, but I'll use this one in any case because it seems to be the one which is being adopted around the place. Mainstreaming plus. And Samoa is already moving in this direction in terms of its agreements with the European Union to provide core funding support rather than project-based support. Essentially what it entails is medium to long-term national planning that encompasses climate adaptation within a program of action that includes all key development-related sectors, be it health, be it education, be it infrastructure and others. For argument's sake, let's call it the Vanuatu 2050 plan. Donors then deliver climate funds, which must of course be additional to existing development aid to support not the programs which they prefer, but to in fact support the national program of action. Their funds can certainly be tied if they wish to climate-related aspects, but the reporting and the planning is streamlined and is entirely responsive to national rather than external plans and priorities. I attended a high-level workshop to discuss these issues in Vanuatu earlier this month, and this proposal was among the most promising and well-supported to emerge from that meeting. So, in summary, there are many climate-related regulatory responses that will need to be based in local-level institutions and sometimes in customary law. Effective land use planning and environmental impact assessment are essential elements. Market-based responses are important, but unfortunately of limited application. Legal responses need to be carefully tailored to each jurisdiction. I would argue against suggestions for model laws in this area of governance, and the delivery of donor funding needs to be revised to support coordinated national planning and action and to end the project-oriented mindset. So just some final thoughts from the founding fathers of the Federated States of Micronesia. These, I won't read it to you, you can all read them, I'm sure. Drafted by delegations from all of the former US trust territories, in not only the states that eventually made up FSM, but also those of the Marshall Islands. Many people in governments and civil society organisations in the Pacific can and are doing a great deal to respond appropriately to the impacts of climate change. Contrary to rumours that adaptation is a scam, I think it's simply a fact of life in the Pacific at the moment. Ultimately, all these efforts will come to nothing, however, if fundamental changes in the lifestyles and economies of the polluting nations do not occur very soon. The words of the Micronesian founding fathers are true in a very deep sense. The world is indeed an island, which of course means that the fate of Kiribati, of Tuvalu, of the Marshall Islands, of Ulithi, of Aniwan, will quickly become the fate of us all if things continue along the current trajectory. So I apologise if I exceeded my allotted 20 minutes, but thank you very much for your generous attention.
Thank you very much. It is now my privilege to introduce Mr. Makoto Robert, who is the Attorney General of the Federated States of Micronesia.
Thank you, Michael. I'm supposed to speak on law and policy, and I regret to admit that I'm not here to speak on either. I'm here in pursuit of the duty of the Department of Justice to search for any body of law, in particular international law principles, that may support the FSM in its quest for preparation to combat the adverse impact of climate change on our shore and our people. And I would be really remiss if I do not take this wonderful opportunity to say something about Federated States of Micronesia, especially for those who have not seen it or never will see it and cannot resort to the map because they are not visible on the map. Micronesia is a geographical designation not only for the Federated States of Micronesia, but for the Republic of the Marshalls, the Republic of Kiribati, the Republic of Nauru, the Republic of Tuvalu, the Republic of Palau, the U.S. territory of Guam, and the U.S. Commonwealth of the Northern Marianas. Of course, in the middle of those is the Federated States of Micronesia. We are so small, that's why whoever designates our area as Micronesia implicitly and knowingly knows that we're micro, we're small. But that even makes climate change a threat to us. I would like also to take this opportunity to congratulate Columbia Law School, particularly Mr. Michael Sharat, the director of the Center for Climate Change Law, and to the government of the Republic of the Marshalls for co-sponsoring this conference entitled, quote, Threatened Island Nations, Legal Implications of Rising Seas and a Changing Climate, unquote. To all of you participants of this important conference, I bring greetings from one of the tiny islands which have politically been named as the Federated States of Micronesia. Federated States of Micronesia is a big nation, about the equivalent to or about the size of the continental United States. However, the land area is very small, consisting of only 270 square miles, about the size of Rhode Island. There are 607 islands which make up the nation of the Federated States of Micronesia. Of that 607 islands, 586 of them are low, flat, no coral islands, the highest elevation of which are not more than 6 feet from the sea level. The remaining 21 islands consist of gentle hill volcanic islands. Irrespective of their nature of their formations, both the mountainous islands and the low islands suffer the adverse impact of climate change. Dependent mainly on land resources, the population of the FSM, as it is conjunctively called, has been dwindled within the last 10 years. From 107,008 people in year 2000 to 102,624 people in year 2010. FSM has an inherent right to continue survival, and the rights of its people to the quality of life guaranteed under the Universal Declaration of Human Rights are in doubtful state due to climate change. The need to take or seek appropriate measure to preserve Micronesian culture and tradition in existence, it is without questions a very, very important one. The Department of Justice feel it is its duty to faithfully execute and implement the Constitution of the Federated States of Micronesia. In that Constitution, it set forth the governmental goals and objectives, and it expresses the sentiment of the people of that nation. In that context, please allow me to quote a portion of the preamble of the FSM Constitution, which declares, quote, "With this Constitution, we affirm our common wish to live together in peace and harmony, to preserve the heritage of the past, and to protect the promise of the future, to make one nation of many islands. We respect the diversity of our culture. Our differences enrich us. The seas bring us together. They do not separate us. Our island sustains us. Our island nation enlarges us and makes us stronger. Our ancestors who made their homes on this island displace no other people. We who remain wish no other home than this. Having known war, we hope for peace. Having been divided, we wish unity. Having been ruled, we seek freedom. Unquote. The role of the Department of Justice in this conference is to seek, and I try to be able to identify the present status of international law in an effort to protect the rights of small island nations to continue survival, and to have identified opportunities for progressive development in international law principles dealing with global problem of climate change. And again, thank you very much. I would like to thank the university, especially for Mr. Michael Jarrett, the Republic of the Marshall Islands, the Greenpeace, and the other entities who have encouraged us to participate in this very, very important undertaking. I leave you with only one thought, and one thought alone. It will not be two, because that would be asking too much. That is, please work or continue to work on whatever project you have, especially with climate change. And if there is any room to include the FSM, please remember. Thank you very much.
Thank you very much, Mr. Attorney General. I'm now happy to call on Dr. Shanho Park, who is legal counsel to the Global Green Growth Institute.
Thank you, Michael. I'm happy to speak is Korean Green Growth Act and its introduction of GGGI. It's a new institute, Global Green Growth Institute. My name is Chano Ba. I'm head of the Global Legal Research Center in Kerala. It's a government think tank. And also I'm in legal counsel of the Global Green Growth Institute. I have experience, not experience, I was in charge of the Korean Green Growth Act and enforcement decree. It's like a code of federal regulation in Korean. And it's also I was drafted in Korean ETS bill. Now it's Korean National Assembly reviewing it's Korean ETS bill. I speak today is the two parts, one of the Korea Green Growth Act and regulation, and then it's the introduction of the GGGI. The regulatory framework is the most important issue in the stage of climate change adaptation in order to optimize the institutional system, such as law and regulation. And although the green growth is to pursue economic growth and environmental protection, the minimum optimized the level of the regulation is a precondition for the global climate change governance. The purpose of the many international efforts for adapting to the climate change is to reduce GHGs without causing charge of impact on market by introducing an effective regulatory system. Low carbon green growth vision aimed to simultaneously is to pursue eco-friendly new growth engine, enhance the quality of life, and contribute to international effort. Why does the Korea's government pursue green growth? Is Korea government, as you know, Korea is not an Annex 1 country. This means that we have no mandatory regulated by the international law. But we set up that the target range, the target emission rate is merely the BAU, business as usual level, is cut down to 30% until 2020. And from a viewpoint of energy, Korea's energy security has been threatened. Korea also is dependent heavily energy import country. Think of the Korean government policy, and there's no choice. We have to change the paradigm to the new, adopt the new climate change agenda. That's why maybe adopted the green growth concept. Korea is not a developed country. Now it's a developing country. We're thinking about it. That's why maybe we need a developed economic development, also a protection of the environment, and is a participate in the international convention, climate change convention. This is just a review. President Lee Myung-bak, Korean president, is proclaimed low carbon green growth as a new vision for the nation in 2008. If the paradigm lasts 60 years in Korea, it's just the economic development. Then the paradigm for the next 60 generation and 60 years is the green growth. just a milestone, this Korea experience. Just you can thinking about this. Just proclaim this Green New Deal, just a national strategy, and we set up this 30% from BAB level, and also a framework act. So it's like a climate change act comparing with other country, but it's a little bit different. We included many things of incentive system and tax incentive. Also, it's a green financing system. Also, it's a command and control system, including MRV system. It's a separate ETS bill. Now, it's the ETS bill is Korean National Assembly reviewing the draft, governmental draft. Yeah, it's just a national strategy for green growth. After the Korean President Lee Myung-bak proclaimed the low carbon green growth, and his government one of the committee, high-level committee, was established for the control tower for the management. Is to manage it is the ministry level, and then maybe we set up the national policy for 5 years. Is a green growth plan. We set up the 3 objectives: increasing energy security, climate change adaptation, new engine for growth, and enhance quality of life and international leadership. And we achieved the 3 objectives. We set up the 10 key agenda, and you can see that. National GHG mitigation goal, just to maybe set up this 30% is the target area, and emissions trading scheme. Just nowadays, Korean is operated command and control system. And maybe some people is very in doubt or is some not familiar with the command and control system. Maybe there are 3 is regulatory method in the reduction to, or is adopting climate change regulatory method. One is command and control system. Second, carbon tax. Third is ETS system. Now it's a proposed ETS system. Also, it's only for the EU region, and it's also New Zealand. And as far as I know, it's the U.S. is a Waxman bill and Kelly-Lieberman bill. Some have a difficult to pass through the National Assembly and U.S. Assembly. Also, it's Australia. It's a carbon. Just maybe we should set up this. MRV system is NGER, National Greenhouse Gas Reporting System. Just maybe Korea is also same. Maybe I've spent 2 years, maybe I adjustment the government policy, I set up the government policy and drafting legislation, command and control and ETS. It's very hard time to negotiate between government and industry. Also, it's really the most hard time to adjustment between the government policy, between the Ministry of Environment, the Ministry of Industry. As far as I know, it's the U.S. same experience, but U.S. Supreme Court is decided this climate change authority is belong to the environment, the EPA, as far as I know. But it's just nice to give it 10 core technologies new growth engine. Just maybe it's a very important for developing country. Maybe legislation system. Just many countries announced that there is a very similar kind of policy, but there is no incentive system from the government through the registration system on legal matter. But Korea is set up that is a supporting incentive system through that Korean Green Growth Act and Enforcement Decree. And it's a 5 sector. It's a very important system. Rechargeable battery and nuclear power development. Nuclear power development is hard to say. Maybe it is clean energy, or is green growth, or is climate change is a method. But in Korea, there's no oil mining. Maybe we needed the nuclear engine for the reduction of the greenhouse gas. Advanced water treatment also, and CCS, carbon capture storage. Also smart grid. But is a GHG emission reduction major industry, second new growth engine. Important things like customize the green strategy for each industry. In 3 components is very important area for the Korea economy. One of the energy incentives, maybe I suggest POSCO is very high, is maybe famous and international famous is steel company, POSCO. its emission rate from the, maybe around 30%, 40%, then among the total is Korean emission rate. Also, is automobile. Korea is a very important sector for the economic development, Hyundai and Kia. So nowadays, it's a big problem between the U.S. and in Korea through the FTA. Maybe it's, last year, maybe I negotiated and I set up this Korean green car standard. It's not a green car standard, fuel efficiency standard for the civil penalty, or so it's civil penalty and it's a supporting incentive. But it's a little bit conflict of between the U.S. policy and U.S. legislation, green car and fuel efficiency standard to the between and Korean policy standard. It's now one of the issues for the FTA between the U.S. and Korea. And product-based industry is like such as there is semiconductor, semiconductor production in Korea. Samsung is a very high, is the power of the market base in internationalization, but is also is a semiconductor production emits some little bit is GH emission. Okay. It's, why is the need for the new regulation framework for green growth? It's conventional is environmental regulation. It's a climate change from the UNFCCC or other is developed country. Just focusing is one norm or is for the next one country, just the prevention, precaution, priority payments. But we need a better regulation. That I think is maybe there should be fewer penalties and more incentive. That, okay. Also, it's the non-discrimination within the same industry sector. Okay, sorry about it. Sector, such as flexible implementation, is very important in a better regulation for green growth. We keep in position in conventional environmental regulation, plus better regulation for green in order to achieve the green economy. GH new objective regulated for the developing country. But is the green economy lead the industry to change corporate strategy, adaptation to climate change, develop green technology, and final goal is creating jobs. Is our goal. But I imagine that until around 2020 is the appearance of Korean economy. This is the result from the green growth act, creating jobs. I don't know. I'm not sure at this time, but I'm sure that it's the Korean government, Korean economy, and will be changed the green economy for the, including creating jobs or something like that. And local government is very important thing. Okay, wait a minute. Just maybe one, oh, sorry about it. One is the leadership, second is technology, third is people. Leadership provides that there is a clear vision for the industry and also to the people. Technology is power to make the economy development. Also is maintain that the current economic increase, something like that. And also its government role is the 5 sectors is very important. Policy signal and regulation and incentive system, and internalized external this economic system. Okay, so just maybe just fact-finding and policy-making, rule-making system. It's my experience. I just roughly shot of that. Is the government have to firstly, government have to fact-finding, have to find the fact-finding. Just make it is the which sector or which regulation or each policy we need that. It's policy analysis that. And also it's a legal analysis. And it's a policy making. I separated 3 of them: national level policy and sectoral level policy and supporting level policy. Something last and supporting level policy, including all of the national level policy, sectoral level policy. And then I think it's policy. In point of the legal view, we needed the rule or regulation or incentive implementation system. Just a Green Growth Act, MRV, ETS, carbon tax. I don't know if carbon tax is good or not, but it's also finally, maybe you need an act and regulation or directive for the implementing its policy. Okay, it's many scholars and many previous speakers already mentioned. Just local level, national level, sectoral level, local level, very important part for the implementation. National level just making the policy, and then it's an implementation rule. But it's a key part of the local level for the implementation, or the local government commission manage climate change risk. And it's a roadmap. Roadmap is a long-term green policy that provides the blueprint to transform the developing country into a low-carbon green growth country. Also, institutional scheme is very important. That's just not an institutional scheme, just governmental structure. That's why the Korean government established on top level green growth committee. Also, as far as I know, Australia is thinking about the new regulatory authority for the climate change. And it's also UK is make it's a climate change committee. Just to make institutional scheme, that's why it's such as green growth for the implementing roadmap. Actual regulation. I think it's actual regulation focused on the four parts. The better regulation for green growth, and less penalty, pure penalty, and more incentive, voluntary participation into green growth society, and also an actual regulation guideline for the green growth. It's for important part for the actual regulation. Okay, I skip over that. Okay, it's the other countries' legislation system. I separated two parts, I separated two categories for the other foreign country legislation. One of the comprehensive legal system, and the individual legal system for climate change. And in UK climate change is like a broad act. It's like a fundamental act. There are some main provision. It's like Korea is also an ETS or it's an MRV system, or is other is a regulatory method. EU ETS directive also, Japanese also. Korea is also a comprehensive legal system we adopted. Individual legal system is like a US MRR. And it's based on Clean Air Act. Just maybe the MRR is provide just MRV system, monitoring, reporting, verification. Austria also, Germany also. It's the EU is 2020 package directive. It's a separate. They have a separate sectoral regulation there. The present legislation, I just focus on two parts. Separate between regulation incentive, comparing, just to briefly review other countries' legislation system. Environmental legislation focus on the regulation. However, it's energy-related legislation. Just we focus on the incentive system. It's like something like RPS system and FIT system. So it's green technology development business important. Just many people is interested in this Korean the green technology and investment system. It is important to establish a support system for the green technology development to achieve the purpose of the law while preventing green bubble. It's a public fund. It's invested from the government to the green investment company. Green investment company can afford to invest green technology. There's no limitation or no barrier to invest the government fund to the green technology. But investment to business, such as a company, so some is a limitation in order to prevent green bubble. This means two limitations. That company should have a certified green technology certification from the government, Also, it's the last wholesale is the rate, it's the market wholesale rate. More than 30% wholesale rate is product should be green product. Is the green investment to kind of that is investment system for the preventing is the green bubble. It's just a short brief, and I think it's Professor Rosemary is very expert for this corporate entity and corporate control entity business criteria. There are two kinds of the corporate entity. Regulatory level for the corporation, one of the corporation level and also facility level. U.S. and its other, okay, just maybe I show that the 1 minute, I just briefly in introduction of the GGGI. Just maybe you can check about the Korean Green Growth Act, you can read that other detailed provision. And also it's MRV system in Korea, and including its command and control. It's very it's unique or it's extraordinary system, but it's just the GH inventory system, one of the data system. It means the environment is a single window for the negotiation. Other is the four sector. For example, MK is like industry power, and West is environment ministry. In ministry land planning, that ministry regulate is their own is a control entity. Okay. So many. Okay. So now is the shortcut that is the Korean Green Growth Act. Just maybe I provide is a short introduction of GGGI. GGGI is a new institute, new for the global climate, global green growth. Nowadays, it's global green GGGI is Korea Foundation, non-public foundation, according to the civil code. But we focused on the support developing country for the making its green growth policy, and also we try to disseminate the green growth is paradigm. It's a change as a new global paradigm. It's such as GGGI also is a relationship on is official relationship with its OECD, with the UN, or also is the WF or Economic Forum, and we have the four principles: global partnership and account transparency, best practice. And just the organization structure is the board, auditor, and 4 team. And regional office is really interesting. From this June, and last May, we established the regional office in Denmark. Also, it's next month we started operate the new regional office in UAE, Abu Dhabi, for the MENA region. MENA region means Middle East and it's North Africa. And so country project is usually provide support developing country in devising their own green growth plan, and legislation and conference sectoral policy program, also implementation framework. And last year, maybe we achieved the 3 complete. Is phase 1 is for 3 countries: Ethiopia, Brazil, Indonesia. And it's just it's a step-by-step approach. It's a screen and build them of policy analysis. Also, it's implementation. Country projects is nowadays tentative. And then last year, just 3 countries. But this year is red color. We already set up for the supporting for developed country. And is GGGI also very considered to Marshall Island or is Cook Island is the South Pacific region for supporting the making the green growth policy. Also is a capacity building program. Just maybe capacity building program is a post sector. It's a manual, is an initial foundation, capacity building, and GGI in-house training program. Also, maybe I skip research part. Also, just a rough idea. It's a broad idea. Maybe in GGI focus on optimized green growth policy for each country. This is our goal. Okay, this is my presentation. Thank you for your attention. It's remain is the other slide. You can check that your website or something, or please email me. I explain many details of that. Thank you so much.
Thank you very much. I appreciate that. We now have some time for questions and comments.
Thank you. My name is Dennis Mutaro, Marshall Island. And I'd like to, first of all, comment on the very informative and interesting presentation by the panelists. Earlier, there was a presentation, and they mentioned, I think it was from Erin Coughlin, and she mentioned about the mangrove trees. And then just later, the presentation by Justin Rose, you also mentioned about the mangrove trees. And I'm pretty much interested in the mangrove trees because, you know, in the Marshall Island, our shoreline are being eroded by the sea level rise and by the waves. So I'm just wondering if we can utilize these mangrove trees. We don't have it in the Marshalls, but if you can utilize that to help stop the erosion from the sea level rise. And in the presentation by Erin, she showed a slide of the bandanus tree that is being planted in many of the islands to stop the erosion. But as you know, the bandanus tree can only be grown where there is also soil. If no soil, it cannot survive. But I see the slides on the mangrove trees. They are being planted in the where there's even the sand. So I'd be very interested to know more about the mangrove trees. Maybe this might be a way to help to mitigate this problem of erosion, and also maybe we can also launch a mangrove tree campaign to try to plant along the shoreline of our islands. You know, of course, people are building sea walls, but sea walls are very expensive, and not all the people can afford sea walls. So, you know, I'd be very happy to get more information. And, you know, the gentleman there, he mentioned about the mangrove trees. So if you can help us to give us more information, I'd be very happy to do that. Thank you very much.
Thank you. Additional, Danielle. Put the microphone.
I was just Danielle Sugarman from the Center for Climate Change Law. I was just looking to ask Justin a bit of follow-up, not to bring the discussion too much back to yesterday on the issue of whether to have a treaty or not, but I was curious after your, you know, very compelling discussion of the need for, you know, community action, whether your particular insight has any impact on how you feel about wider government interaction.
Specifically to a treaty.
Or with regard to how broader governments can come in to help in light of the communal nature of a lot of the social structure.
In relation to migration specifically?
Migration or adaptation.
Right. Well, I think it's a very broad question, so it's hard to provide a focused answer to it, I guess. I think that I'm closest to these issues in Vanuatu, where I'm living and working quite closely with the people who are in Vanuatu, and it's a very detailed process. So from a legal point of view, it's not led by law. Law is just one of the tools, one of the mechanisms which can respond in some circumstances, but most of the responses are completely apart from law. So the legal responses are sometimes appropriate, but most of the time it's to do with the technical issues, it's to do with the social issues, it's to do with the economic issues, and it's very island specific, it's cultural specific, it depends on the time and the place, and so It's about governments working very closely with the, particularly in the countries where I work, working very closely with the householders, with the village level institutions, with subnational governments, providing good information, providing accessing the best technical data from the best scientists, from the best range of experts from all the different disciplines, from having a good understanding of what the real conditions are on each island. And so there's no broad response, there's no general response. It really is about a lot of detailed and empathetic and technical work. To give you one insight into Vanuatu, they're talking about food security in the agricultural sector. The agricultural review, one of the sectors, identified every single food species, and it identified every single climate impact and every single climate risk, and created a matrix such that people can see what the risks are, what the vulnerabilities are for every species, for every microclimate grown throughout the whole set of islands, so they can then begin to work with farmers and work with the agricultural experts to put in place mechanisms to increase resilience and to decrease threats to food security. Law had nothing to do with it, but that's just an insight in one country in one of the sectors.
Ambassador.
Thank you very much. Thank you to the panelists and their very useful presentations. I want to ask first to Mr. Chan-ho Park. I saw your description of your presence or your future presence all around the world, and I didn't see much teeny countries and island countries. So I want to ask you if the green growth is only for the big countries and not for us. So if you think about that, I would like to have your views on this, because I think it's very useful in the time where we are talking about economy, green economy, and we don't know exactly what that means. But green growth, I understand it better, and I think that all of us can learn from you and from what you have in mind. I wanted to say to the General Attorney of FSM, Federated State of Micronesia, that what he told us, and his predecessor there from Marshall Island on the islands, and their struggle for surviving is very inspiring. In fact, I came here to learn and to strengthen in me the conviction that there is always hope for everybody. And what I learned from you today give me more strength and more willing to struggle, to continue to struggle in this climate change battle. And I wanted to say that, you know, my country, Cape Verde, at the beginning in 1975, we was visited by experts from the Bretton Woods organization. And after their study, they taught to us that we was coming from a long struggle, armed struggle against the colony at the time, and good friends now, Portuguese. They told us that our country was not viable, just like that. And we had 14 years of armed struggle against the colonialism to get our independence. And imagine our authorities at that time, two experts with the strength and the weight of specialists and experts to tell you that your country is not viable. And they said that because, of course, there is not natural resources in my country. We don't have gold, diamond, petrol. We don't have nothing. We have only 10% of our land, country, good for agriculture. Very few water. And drought, desertification, great percentage of poverty. So for them, it was not viable. But my prime minister at that time told them that this is the unique country we have, and we have to fight for it. We fight for its independence, we have to fight for its survival. And 36 years later, we are a success story of Africa. We passed from 300 US dollar per habitant in 75 to 3,600 in the 2000. We increase the land, cultivable land. We decrease from 41% of poverty in 70s to 21% at this moment. We have 99% of our young youth at the school, girls and boys. We are democracy going well, so we are healthy. Of course, there is climate change, and we are struggling against climate change too, because what is the lesson from what I heard all these 3 days, and this is why I participate to this conference, and I try to be here every day. It is that hope is always an option. And even when we hear these stories on the Micronesia, Tuvalu, Marshall Islands, and the situation where we are because of the climate change and of the pollution of the air, that we are not responsible, I think that hope is always an option, and we have to continue to battle for that. And what I take from conclusion from my stay in this, from my participation to this conference, is that I have to continue to be in houses, somebody who is going to continue to struggle for us, and we have to take lessons from what we heard here. For example, this mangrove example is a very good example, and we have some examples and some lessons to get from the academics and to get from the experts who went to our countries. And I thank you very much for what you have done, what you are doing, and to continue with us to collaborate for our survival. Thank you very much.
Thank you.
Yeah, I think adaptation can be considered as a proactive policy to reduce the loss and damage related to climate change, also to reduce the flow of migration, climate-induced migration. My concern is that is community-based adaptation is found in some countries like Bangladesh. I'm from Bangladesh, Hafiz. This provides a bottom-up policy approach. My concern is that how can we recognize these community-based organizations who are actively participating in the local level decision-making process? So how can we recognize them legally? That is my question to particularly Justin Rose. Would you please respond?
If I were being asked that about a country with which I was quite familiar, I'd be able to perhaps give you a quite a straightforward answer. I know enough about even Pacific Island countries, many of which are quite similar. In the Attorney General's country in the Federated States of Micronesia, they're beginning to do that, but they're doing it in different ways, even in different states within the same country. In Vanuatu, they're doing it in a very different way to how they're doing it in Samoa, and differences between a lot of the mechanisms in which, there are many examples, and perhaps the best way for me to help you to answer your specific question would be for me to give you examples of legislation from many different areas of the world, including some places in South Asia, which might be most useful for you to apply to a Bangladesh context. Because the ways in which the Pacific have done it, to give you an example, back in 2001, I was asked to do something similar in Pohnpei in the Federated States of Micronesia, and I was reasonably familiar with the jurisdiction, but not being fully familiar with the jurisdiction after meeting with the various stakeholders, I adjusted a model from Samoa, which in many respects was similar but was sufficiently different that it didn't work, because it was from Samoa. So these particular laws, more so than any other law that I've encountered, need to be tailored specifically for the cultural context, for the ecological context, for the historical context. They need to take account of the existing relationship between the state and the non-state institutions which you're trying to recognise.
I have a question that I'd like to ask Dr. Rose. Your slides indicated that in at least 2 of the states you discussed, environmental impact assessment is required of adaptation measures or the adaptation implications of certain actions. And I'm interested in learning a little bit more about that. Are there protocols on how that analysis is to be discussed? Has it led to useful analysis? Has it had any effect on decision making, if you know?
Thank you, Michael. Yes, I mean that's would be my, in terms of my advice, particularly for Pacific Island countries, but really for every jurisdiction. I would say that's a first step. If you're thinking about how to integrate, how to legally respond to climate change and to integrate concerns relating to climate change adaptation into law, begin first with the environmental impact assessment process. I mean, and there's an enormous wealth of information which is available, being generated by ecologists and climate scientists and others, and that can flow very effectively into the environmental impact assessment decision-making process. The legal ways in which it can be done in terms of drafting and so forth are really quite straightforward. It's just it becomes one of the criteria which decision-makers need to consider. They need to consider the best evidence in relation to climate risks, climate vulnerabilities, in relation to sea level rise, which has been something which has been discussed a lot in the last few days. The speaker this morning talked about the time scale which you would want to be integrating into that. That's something which would need to be given careful thought of, and that would need to be drafted into the legislation. But in terms of how it was done, it essentially becomes a criteria of the decision-making process within both the people who are preparing the environmental impact assessment statements and the people who are making decisions regarding development and conditions to place on the development if it's approved.
The United States has been struggling for some time with how to consider climate adaptation issues in the environmental impact assessment process. About a year and a half ago, the Council on Environmental Quality, which is the part of the White House that administers the U.S. law, the National Environmental Policy Act, issued draft regulations on consideration of greenhouse gas emissions in the environmental impact assessment process, and said that impacts of climate on projects should be considered, but it has not yet come out with any detailed rules on just how to do that. And I'm wondering if some of the states you discussed have advanced further than that.
Well, in terms of emissions, the whole region would emit less greenhouse gases than just the island of Manhattan itself. So,
sure, the emissions, I understand.
So the emissions we don't worry about so much. There are so few of them. In a political sense, it's good to reduce them, but to the extent that mitigation occurs, it's mainly where it coincides with human development. Right. I could give you an example. I mean, I could show you what they've done in Kashrai, what they've done in Vanuatu. I'm certainly no expert on US law or US environmental law. To the extent I'm exposed to it, it seems to be the most prescriptive I've encountered anywhere. The texts themselves are
right.
Really
I'm more
very
interested
long,
in the assessment
really
of the adaptation aspects in looking at projects.
Right. I mean, there's discretion given to the decision makers. The provisions themselves are really quite simple. They require the decision makers to consider the climate risks and the predicted impacts and the vulnerabilities, and they place obligations on them not to approve development which is going to increase risk or vulnerability where it can be feasibly avoided. Sure. And then and so it's not prescriptive. Mm-hmm. Tends to be kept simple, particularly when I'm assisting in drafting legislation in the Pacific. Try to keep it simple and to allow for the discretion of the of the technical decision making.
Thank you.
Just to complement on that, my name is Natalie Riss. I'm an independent environmental and sustainability consultant. Just to complement on this question, I don't know if you're aware that the OECD DAC SA task team, Strategic Environmental Assessment Task Team, launched an advisory note, which is a guideline on how to integrate adaptation to climate change into policies, plans, and programs of countries. So these guidelines have been endorsed by the Development Assistance Committee in 2008 and are now published by the OECD. And I have been a co-author of these guidelines, so I would be happy to provide you or any other people here in the audience with the website and more information on it if needed.
Good. Please do.
Thank you. Alawon Ishoda from the Marshall Islands. First, let me just congratulate the panelists on the fascinating presentation. I'm just here to provide some experience also to the question raised by the gentleman from Bangladesh regarding how to recognize the CBOs. And I think, Justin, you really hit it on the nail. You need to understand the relationship between the state and non-state actors. Because one of the beauty of how things are easily streamlined in the Marshall Islands is because my organization as an NGO is one of our biggest partners is the government because we are able to provide certain services with the communities, to the communities, and sort of bring the top-down or bottom-up approach back to the government, our government partners, to decide on policies. The other thing I wanted to also raise up in that sense is I think there needs to be more coordination between the different existing conventions within the UN system. We have the UNFCCC, the CBD, and the Ramsar conventions, and both the CBD and the Ramsar, as we've heard from previous presentations, can contribute to elements of adaptation, but I don't think there's enough talk that is happening between the different conventions and secretariat at this moment. So perhaps that's another way of moving forward towards recognizing CBOs, because CBOs really drive the adaptation from the perspective of biodiversity conservation or even implementation on the ground. So perhaps if there's some more dialogue on this, then we can all, instead of reinventing the wheel, start to discuss and streamline funding. And I'm also glad that you brought that up, Justin, about the funding issue, because as I mentioned also in my presentation, it's a reality. Thank you.
Thank you. Well, we'll take our lunch break now. Lunch is upstairs, as it has customarily been, and we will resume at 2:30 for our final session. Thank you very much. Thank you. Thanks very much. Appreciate it. Thank you.